A routine bond hearing was about to take a dramatic turn. The judge had already warned Mr. Brown that failing to follow her instructions could send him back to jail. But instead of simply answering the court's questions, Brown repeatedly challenged the court's authority and insisted on using his own legal terminology. The judge had been patient. She had explained the consequences. And now, the warning she had given him before was about to become a reality. The question was no longer whether the court had jurisdiction. It was whether Brown had followed the specific order that was keeping him out of jail.
So here's the thing, Mr. Brown, I told you very specific instructions when you were here before that if you did not do what I asked you, then your bond would be raised and you would have to go back to jail, right?
No.
Yes, that's exactly what I say, because you've heard me say it probably 8 times already this morning. So at this time, Mr. Brown, because you did not do what I asked you to do or what I ordered you to do, I'm going to raise your bond.
Challenge subject matter jurisdiction.
That's overruled. Listen, Mr. Brown, I'm raising your bond to $100,000 in each of your cases for not following the court order. Go back with the bailiff. Go back with the bailiff. Go back with the bailiff. You're going to make it worse if you don't.
Yeah, respectfully, this is not a fair trial.
You don't get to say respectfully and then be disrespectful. You're appearing here today.
My special appearance.
I understand what you're doing and what you're trying to do. It's not going to help you a single bit in court to try to play these games.
And challenge subject matter jurisdiction. Going on record.
Okay, what does that mean?
Okay.
You just determined to use different words and be difficult, aren't you?
Yeah, respectfully, this is not a fair trial.
You don't get to say respectfully and then be disrespectful.
You through in, Judge?
Yes, I'm through.
I am not a threat. Any officer, let's go. Why are you my hand?
Good morning. Are you Nasir Brown?
I'm not here today on special appearance.
I'm sorry. Speak up so I can hear you.
Here today.
You're appearing here today?
My special appearance.
Okay, what is your name?
I'm a third party intervener. On behalf of court official legal entity, Nasir Brown.
Okay. At one point in your at some point in your life prior to being this third party, were you Nasir Brown?
No.
You're not him.
I'm a third party intervener.
So here's the thing. If you don't tell me your name, I'm going to put you in custody for not cooperating this morning. I'm not going to hold on. I understand what you're doing and what you're trying to do. It's not going to help you a single bit in court to try to play these games.
That's relative.
So are you Nasir Lewis Brown, or have you been him at some point in your life or not?
Yes.
Okay. So I'm going to call you by Mr. Brown because I'm not going to say all the words that you just said, because you have now identified yourself as Nasir Lewis Brown. And so, Mr. Brown, this is your initial appearance, and you have 2 cases. And cause number 26, I just asked you not to speak over me. So here's the thing, Mr. Brown. I'm going to be very patient.
And at the challenge subject matter jurisdiction, going on record.
Your challenge of the subject matter.
The judge has now directly rejected Brown's challenge to the court's subject matter jurisdiction. That ruling is important because the court is moving forward with the initial appearance and the criminal charges against him. At this point, the discussion is no longer about whether Brown can simply redefine his legal status in the courtroom. The judge is treating him as the defendant in the cases before the court and is proceeding with the formal charges.
Our jurisdiction is overruled. Let me go through what I need to go through, okay? So this is your initial appearance, your first day in court. I'm required to go through what you're charged with by indictment. In cause number 26, DCCR 0322, you're charged with a 3rd-degree felony offense of assault family violence by impeding breath or circulation from February 16th of 2026. And then in cause number 26, DCCR 0323, you're charged with the state jail felony offense of injury to a child, and that's from February 16th of 2026. And so since you have made bond and got out of jail on your cases, have you had an opportunity to try to hire a lawyer? Speak up so I can.
Up and down.
It's been up and down?
Yes.
Okay. So here's what I'm going to do, Mr. Brown, is I'm just like everyone else. I'm resetting your case about 30 days to give you some time to try to hire a lawyer. You need to try to get someone hired before the next court date. If you do, Just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying and we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order and you would go back to jail. Do you understand? I'm sorry?
Overstand.
Say it again.
Overstand.
You overstand?
Yes.
Okay. What does that mean?
Overstand.
Do you understand what I'm saying, sir?
Not blind.
You'll oblige.
Not blind. Yeah.
Okay. You just determined to use different words and be difficult, aren't you?
No.
Okay. So as a condition of your bond, did you have a condition that you were not to have any contact or communication with the complaining witnesses in each of these cases, right? Okay. And so I want to make sure you understand the importance of that. And that if you do have any contact or communication with either of them, it would be a violation of that bond condition. If I find out your bond would be raised and you would go back to jail. Do you understand that as well?
Overstand.
You overstand. I'm going to guess that overstand is even better than understand. So you definitely know what I'm talking about, right? So we don't have any miscommunication today. You know exactly what I'm talking about. So I'm going to have you step in front of the clerk. You're going to sign a reset notice so you know when to be back in court and take care of those things before the next court date. All right, step in front of the clerk. Nasir Brown. Are you Nasir Brown?
I'm sorry. We were here before.
You've been here before, but you have to speak up where I can hear you.
Executing beneficiary of the trust in hand.
Of the trust of what?
Of the trust in hand, yeah.
Of the trust in hand? Whose hand? What trust?
The execution.
Did you bring a copy of it?
I wasn't able to get to the copy. I do have.
Take the glasses off. I need to see your eyes, please.
These are my prescription glasses.
That's okay. So I'm having a hard time understanding you. You need to speak up and speak clearly so that the record can be clear. You were already here and I gave you an opportunity to try to go hire a lawyer for your 2 cases. Did you get a lawyer hired?
Able to do it.
Who'd you talk to?
Made a few calls to the guy, Rafe. What's his name? Rafe King?
Mm-hmm.
What's his name again?
Who else?
That's the lawyer that I chose.
So if you chose him, you should have gotten him. I mean, he has the same, there's somebody that answers his phone every week. I understand. I know how it works. I told you to hire someone or visit with at least 3 lawyers.
Made an attempt.
You made an attempt? Okay. Did you go see Mr. Kimler? Did you make an appointment?
Able to do that.
Why not?
I'm not in a position.
This is the moment where the earlier warning begins to catch up with Brown. The judge had ordered him to either hire an attorney or speak with at least 3 lawyers and return with information about those efforts. Brown says he made some attempts, but the judge begins asking about the specific lawyers he was supposed to contact. When one of those required steps was not completed, the court was left with a critical question. Was Brown making a genuine effort to comply, or had he failed to follow the order despite being told exactly what was required?
To go back and forth in front of a lawyer that's in this state that I'm not funding this is for the age.
So here's the thing, Mr. Brown, I told you very specific instructions when you were here before that if you did not do what I asked you, then your bond would be raised and you would have to go back to jail, right?
No.
Yes, that's exactly what I say, because you've heard me say it probably 8 times already this morning. So at this time, Mr. Brown, because you did not do what I asked you to do or what I ordered you to do, I'm going to raise your bond.
Challenge subject matter jurisdiction.
That's overruled. Listen, Mr. Brown, I'm raising your bond to $100,000 in each of your cases for not following the court order. Go back with the bailiff. Go back with the bailiff. Go back with the bailiff. You're going to make it worse if you don't.
Yeah, respectfully, this is not a fair trial.
You don't get to say respectfully and then be disrespectful. Go back with the bailiff.
She started.
He's gonna make me lay hands on you.
Why would you lay hands on me?
Because you're not doing it, I'm telling you now, go.
Mr. Brown, you need to go back with the bailiff. Right now, I've raised your bonds. You have to go with the
I am
bailiff.
not a threat to any officer.
You through in, Judge?
Yes, I'm through.
I am not a threat to any officer.
Let's go.
Why are hands on me?
Yeah.
Why are
I
hands
told you I was gonna put hands on you.
Why are hands being put on? Y'all see this on the camera?
And right there, put your hands on the wall. Okay. Put your hands on the wall, because you're not listening. Don't listen. I don't surprise that.
The courtroom exchange ends with Brown being ordered to leave with the bailiff after his bond was raised. What began as a hearing about compliance with court instructions escalated into a direct confrontation over the judge's authority and Brown's refusal to accept the court's ruling. The judge had issued multiple warnings, the bond was increased, and the courtroom now had to enforce that decision. This hearing shows how quickly a routine criminal proceeding can escalate when a defendant refuses to follow a court order. The judge had warned Brown about the consequences of noncompliance, gave him instructions about obtaining legal representation, and later concluded that he had not done what the court required. The bond was then raised by $100,000 in each case, and the courtroom confrontation intensified as Brown continued challenging the court's authority. Whatever viewers think of the judge's decision, the key issue in this hearing was not simply the language used in court. It was whether the defendant followed the specific conditions and instructions that had been given to him.